Hello, Bebop here, and welcome to I Fought the Law. Today we are looking at a little shindig between the British government and the Irish group, Kneecap. Kneecap is a Belfast-based Irish-language hip-hop trio known for their provocative politically charged rap that explores working-class youth culture, republicanism, and drug culture in Northern Ireland. Composed of Mo Chara, Mobley Bar, and DJ Pro V, their stage names, they gained notoriety for their 2017 debut single, CEARTA, which was based on an incident in which Mobley and a friend were out spray painting the day before a march in support of an Irish language act. Mobley had written "Cheater" rights on a bus stop when police arrived. He fled, but his friend was arrested and spent a night in the cells after refusing to speak English to the police. The group subsequently released albums 3CAG in 2018 and Fine Art in 2024, alongside an award-winning 2024 biographical film. They perform most of their lyrics in Irish. On the 21st of November 2024, the defendant, Liam O'Hanna, performed as part of the group at the O2 Forum, Kentish Town, in London. It was alleged that Mo Chara, O'Hanna, brandished the flag of Hezbollah, which in the UK is a proscribed terrorist organisation, after someone from the crowd handed it to him. O'Hanna maintained that he was unaware of the identity of the flag, which was handed to him by a fan in the audience in the heat of performance, and he simply draped it over himself. On the 21st of May 2025, at 12 o'clock, the Metropolitan Police issued a notice of criminal charge. This notice required the defendant to attend a hearing at the Westminster Magistrates Court at 10 o'clock on the 18th of June 2025. Liam O'Hanna was subsequently charged under Section 13 of the UK Terrorism Act of 2000. Section 13 of the Terrorism Act makes it an offence for a person to wear or display an article in such a way or in such circumstances as to arouse reasonable suspicion that they are member or supporter of a prescribed terrorist organisation. The offence is committed only if the person carries out such conduct in a public place. In response, artists including Annie Mac, Beager, Bicep, Big Pig, Blind Boy Boat Club, Bob Villain, Christy Moore, Damien Dempsey, Delivery, Dex Ease, English Teacher, Enter Shikari, Fontaines DC, Gemma Dunleavy, Gurius, Idols, Iona Zajac, Jelani Blackman, John Francis Flynn, Joshua Idhen, Katie J. Pearson, Kojak, Lankum, Lisa O'Neill, Low Key, Massive Attack, Martin Ware, Paul Weller, Peter Perrott, Poor Creature, Primal Scream, Pulp, Roisin L. Sheriff, Shirley Manson, Sleaford Mods, Soft Play. The Merry Wallopers, the Pogues, Thin Lizzy and Toddler T signed a letter advocating for free speech and alleging that Kneecap were victims of a campaign of intimidation. In an interview with The Guardian, on the 27th of June 2025, the band responded to the charge, while saying, "We do not, and have never, supported Hamas or Hezbollah." They also described the recirculation of the videos as a smear campaign against them, with the footage deliberately taken out of all context. The point is, that wasn't an issue until we said, "Free Palestine," at Coachella. That stuff happened 18 months ago, and nobody batted an eyelid. Everybody agreed it was a fucking joke, even people that may have been in the room that didn't agree. It's a laugh, we're all having a bit of crack. The point is, and the context is, it all resurfaced because of Coachella. That's what we should be questioning, not whether I regret things.
Kneecap's opponents, he says, went and combed through 8 years of a career. They're really scraping the bottom of the barrel. He says that they then took those videos out of context. If you believe that what a satirical band who play characters on stage do is more outrageous than the murdering of innocent Palestinians, then you need to give your head a fucking wobble.
Now, of course we can debate the rights and wrongs of that, and whether calling yourself satirical allows you to say whatever you want without repercussion, just as we can debate the right to free speech and whether there are limits on that right. But I'll leave that to others and stick to these facts before us, because to do anything else would be to do exactly what Kneecap is saying. The criminal prosecution was simply a tactic to take the headlines away from the massacre of Palestinians in Gaza and the British government's complicity in that massacre, a point underlined by the many artists who signed the open letter mentioned earlier. What I want to look at is the lore involved and try and make sense of the criminal proceedings against Ohana. The defendant faced a single charge that, on the 21st of November 2024, in a public place, namely the O2 Forum, Kentish Town, London, displayed an article, namely a flag, in such a way or in such circumstances as to arouse reasonable suspicion that he is a supporter of a prescribed organization, namely Hezbollah, contrary to Section 13, 1b, and 3 of the Terrorism Act 2000. The matter never got to trial. Before we continue, it is very important that you understand that the charge under Section 13 was a summary offense. In the old days we called it a misdemeanor. The trial would have been in front of a judge only, no jury. At the same time, because there is no jury, the maximum sentence that could be handed down was up to 6 months imprisonment, or an unlimited fine, or both. In other words, this was not regarded as a particularly serious offense and therefore did not merit a jury trial. The majority of summary offenses are dealt with in one sitting. That is if they go to trial at all, as many summary offenses allow you to pay an admission of guilt fine, like a parking ticket. Section 13 does not seem to provide that option, but again, usually it would have been dealt with speedily by the judge. The reason that the matter never reached trial was that the defense was successful in their argument that the court did not have the power or authority to hear the matter. The defense argued, pursuant to Section 117, 2a of the Terrorism Act 2000, proceedings for a Section 13 Terrorism Act 2000 offense, which appears to be partly connected with the affairs of a country other than the United Kingdom, can only be instituted with the consent of the Director of Public Prosecutions, who, in turn, must have the permission of the Attorney General to do so. The relevant consent was neither sought nor granted until the 22nd of May 2025, which was 1 day outside the statutory time limit provided by Section 127 of the Magistrates' Court Act 1980. In other words, because another country apart from the UK was involved, the charge could have international repercussions, and therefore the criminal proceedings can only go ahead with the blessing of the Director of Public Prosecutions and the Attorney General. Section 127 says this must all happen within 6 months of the offence being committed. The Metropolitan Police did secure that blessing, but they were 1 day late. So, in essence, a procedural requirement that would have legally ratified the criminal proceedings against Ohana was not fulfilled. Oops. The Crown argued that the institution of proceedings for the purposes of consent from the Attorney General is the point at which the defendant comes to court to answer the charge, not, as in this situation, the issue of the notice of requisition and charge under Section 29 of the Act. In other words, the prosecution argued that those permissions were not needed until Ohana was due to appear in court to enter a plea of guilty or not guilty. The judge, Paul Goldspring, who is Senior District Judge, Chief Magistrate, for England and Wales, disagreed with the Crown Prosecutor and ruled that for summary offences, proceedings are instituted at the moment a written charge and requisition is issued, not when a defendant first appears before a court or enters a plea. The judge pointed out that summary proceedings means just that, a quick and speedy procedure which is often completely dealt with at the first hearing. Accordingly, for the matter to be further delayed by allowing the prosecution to only seek the necessary consent after the defendant had pleaded, did not make sense, as this would turn what was supposed to be a speedy procedure into a long, drawn-out procedure that we often see in jury trials.
I find that these proceedings were not instituted in the correct form, lacking the necessary DPP and AG consent, within the 6-month statutory time limit set by Section 127 of the Magistrates' Court Act of 1980. That time limit requires consent to have been granted at the time of or before the issue of the postal requisition and charge pursuant to sections 29 and 30 of the Criminal Justice Act of 2003. Consequently, the charge is unlawful and null. This court has no jurisdiction to try the charge.
The Director of Public Prosecutions has appealed the decision to drop the case. Lord Justice Eddies, who is hearing the appeal with Mr. Justice Linden, told the court, "We will be reserving judgment in this case." This means they will hand down their ruling in the case at a later date. Lord Justice Eddies said the submissions had given us a great deal to think about.
The appeal has real legal effect. It is not just a clarification of point of law. It seeks to overturn the dismissal ruling. If the appeal succeeds, the CPS would be able to proceed with the prosecution, because the original dismissal on jurisdictional technical grounds would be undone. The fact that the British government, through the DPP, is appealing the decision, which involves a minor offence, and where the judgment appears to be legally sound and not that complicated, seems to support Kneecap's assertion that the whole proceedings is to divert attention from the complicity of the British government in the massacre of Palestinians. Watch this space for news of the appeal. This has been I Fought the Law, and I'm Bebop Olula. Until next time, adios.